1 second. Friends, we are starting now. Today is the 208th Friday group meeting. The topic is Foreign Judgments, Indian Execution. The speaker is our beloved topmost senior advocate of this country, Mr. Justice, retired Dama Seshadri Naidu, senior advocate, former judge of Kerala and Bombay High Court. Sir, thank you very much. Thank you, sir. Sir, you earlier also addressed our Friday group on 2nd December 2022. Your viewers are 31,000, sir. The art of legal drafting. It's a wonderful, very good research and other thing, lot of inputs, and people appreciated all over India also in the YouTube channel itself. And second one is 24th March 2023. That is, the topic is law and literature. Total 37,700 viewers. You have contribution for our Friday group, sir. Now you can initiate your lecture, sir.
Thank you very much, sir. Seshagiri ji knows about one author in Telugu, because last time I just had the lesson, our lecture on law and literature. I'll continue where I just stopped. And in a song he says, in a song he says, every day the sun and the moon come. Do you think they are coming for you? No. One in a crore of this country, of this universe, is a noble person. And they come for them, and you enjoy the warmth. And one such person is Seshagiri.
So nice, sir.
Imagine the meticulous way he prepares, and he stalks you literally wherever you are. Once he targets you that you should be the next speaker, there's no letting out. He would be after you. He will ensure your presence, and 10 minutes you would get a reminder. See the focus. What is that for? What is that for? Just to disseminate knowledge to the extent possible. That's why the sun and moon should come for him. We enjoy the warmth. You know, when you walk with an old man, I don't know whether you learn or you don't learn, but you will learn some few tricks, because life teaches some tricks. And we may divulge some secrets as well. Can I tell you a secret? It's no longer a secret, but for me it's a secret. You want to be a very good counsel, an advocate. On your feet you deliver and everybody gets inspired. Right? How is that possible? Can you tell me one method that the art of delivery on your feet? Could you tell me one method? Then I'll tell the method I think is the right method, or one of the methods. Tell me, how could you be a wonderful arguing counsel? Leave alone the subject. I'm talking about the style of delivery. Storytelling, quite an obvious one. Move ahead, a bit move ahead. Storytelling is narrative skill. How about the style, the delivery, and the cadence, the diction, all these things? How do you get it?
By watching.
By watching? Right. Should I spill the beans? Thank you.
By observing people.
Should I spill the beans?
Yes,
Hold
sir.
your breath. Be a singer. Be a singer. Try to sing for a couple of minutes every day. I'll tell you why. You know, singing contains many emotions, right? And it also has an element of fear. And once you become a singer, you know how to suppress your fear. And before the court, we are afraid of delivering, thinking people are watching, and then whether they give an order or not. So if you are a singer, you know how to conceal your emotions. And also, your vocal cords get trained and you become free. This is one secret. Now let me tell you the other secret. You want to master any subject. Say for example, I wanted to master CPC. What should I do?
Read CPC.
Quite an obvious answer. Can anybody contribute anything else? Many people feel I should read Mullah, or I should read Thakkar, or I should read N. Saha. True. But the problem with best commentaries, for that matter any commentary, is this. You will have very succinctly a legal principle set out. And if you keep reading one particular section, you will have many contradictory principles as well, thanks to the law of precedent. So at the end of the day, it becomes a jumble of confusion. So my suggestion to young lawyers in front of me and those who are watching is that please ensure that you read a law journal, one law journal you choose, and read cover to cover, nothing else. And I don't think anybody can stop you in your progress as a lawyer if you practice. You know what happens in that one? Every case deals with, say, one legal principle. When you read that abstract, you tend to forget. But when you read in the context of the facts, it's story unfolding. So the legal principle is explained in the backdrop of facts. So you're reading a story at the end of the day, and you tend to remember that one. Right? Now should we move to the subject? The subject, as I've thought, is foreign judgments and Indian execution. Thanks to economic liberalization, now we don't have that much of a craze. I come from a place called Tirupati. In 70s and 80s, as a student, we were all crazy of foreign goods. We used to go to Madras, then Madras, today's Chennai. There is different markets, Lingichetti Street Market, Moore Market, and all those things are there. There you used to buy. So somehow inherently, we love anything foreign. That's why perhaps foreigners have ruled us. Then, is it necessarily true that we should love even foreign judgments? That's the question. I tell you, I was talking about one movie in Tamil, that's Ninathala Inikum. It's in Telugu, Andamaina Anubhavam, means a beautiful experience. Right, in that one, that comical character in Singapore, the backdrop of the movie was in Singapore. It was released in 1979. Most of you must have been born or could have been kids, right? Right. In that one, he goes to a shopping mall somewhere and he buys a lot of foreign goods. Everything, all toiletry, etc., etc. He comes to the room and proudly displays to his friend, that is Kamal Hassan. You see, I've bought so much. They're all India made. This man becomes furious and goes back and asks him, "You cheated me. How could you sell me Indian goods in the name of foreign?" And he coolly replies, "India is foreign to Singapore." Right. Now, when it comes to conflict of laws, Seshagiri sir has told me, "Sir, kindly avoid something very dry, something very academic. Try to illustrate if you can, or articulate your points with certain examples such as case law, so that you can drive home the point whatever you want to." So, for the first time, I am compelled to, and I may be forgiven for that I have to refer to some notes, because I need to refer to case law, which is not possible to just learn by heart or to keep that in mind and then articulate. So, I may be given that liberty to have a look at a glance at certain judgments, so that we could have the point. You see, this conflict of laws, and it also has an alternative name, that's private international law. And earlier, we were hardly coming by any cases we were required to handle. especially between 1950 and say, for example, until 1980s. 1980 onwards, with liberal economy, borders have been thrown open, and now we have become a diaspora. That's why we need to deal with, and borders have been banished in the sense that all internet commerce has come. It assumes more importance in that context. But before 1950, it was a very vibrant branch of law in India. You know why? Would anybody guess? Have a guess. An absurd guess will have a chocolate later
Our
outside.
constitution hadn't come into play then, and there were conflicts of private laws of princely states.
You're right. You know what happened? Thank you. You know what happened? For example, Baroda was foreign to India. Hyderabad was foreign to India. So all these princely states, they had not been integrated until after the independence. So whatever the law that dispute, suppose neighboring, if you are in Baroda, the next part, that's another territory, and you contract there, you come over here, then comes. So up to 1950, it was vibrant. And thereafterwards, it has tapered off. And again, thanks to economic liberalization, from 1980s onwards, it has opened up. Now, there is a lot of disagreement with regard to what name it should be given, because conflict of laws, as some scholars feel, is a misnomer. Misnomer means a wrong name. Mis means wrong, nomer means name. Right? It's a wrong name. It's a wrong name because there's no conflict at all. It's only a choice of law. There are two persons litigating. One comes from, say, England, the other from India, and they contracted. It could be a marriage as well. They contracted. And then there's a dispute. And he says that my law should be applied, and I say that my law should be applied. So this is where you have to choose between these two laws. You know, when it comes to laws, there are two types of one is domestic law or municipal law, the other one is international law. So international law governs the countries. When international law has to govern individuals of different nationalities, this is what we call private international law. It is private, but international law. Again, it's a misnomer, because there's nothing international. At the end of the day, you have to apply the domestic law of one country or another. That's why Germany prefers to call it international private law. That's a better name, in fact. But what's the name? As in Romeo and Juliet, they say, a rose is rose, it's sweet as smell, whatever the name you call that with. So, convention has demanded conflict of laws or private international law. The best of commentaries, for example, the most authoritative commentary you could ever have on this subject is, what is the term? Dicey, Morris and Collins, private international law. An Indian best book available, perhaps, to my knowledge, is that of Atal M. Setalvat's Conflict of Laws. And another student book, really good book, young lawyers wanted to have a look at, that is Paras Diwan's Private International Law. So these are all there, right? Now, we have to secure a judgment somewhere, right? Once we secure a judgment, that has to be enforced. For that purpose, we will enter into certain treaty obligations. That's why when you want to enforce any judgment from another country, first of all you have to decide whether it's a treaty country or non-treaty country. You know, when I was working in Kerala, we had, at the time, not now, in 2014-15, etc., we were getting frequently certain writ petitions and other proceedings when I was sitting over there, that some collection agents from some Dubai bank, the Indian agents, they come and they threaten them, you pay the money with great respect without anything demeaning or pejorative in that sense. I'm just quoting out of my experience. And they complain that we have gone to the police, asked protection, they did not give, these people are hooligans, and they are demanding repayment. I don't owe any money in any country, wow. I asked one advocate, why this Dubai people, Dubai bank, contracting with some muscle man in the Kerala and threatening somebody that you have not paid. You know the reason I tell you, those days, that some people, those who have settled, the diaspora of Kerala there, they may have to do something, they borrow some money in Dubai, and they difficult times they hit and they default and they run away, they come out to their country. There is no treaty between Dubai and India. They cannot enforce that one. So they have to fall back on muscle. Now I think 2018, Dubai has entered into a treaty obligation. UAE, United Arab Emirates, they have entered into a treaty obligation with India. Now they can enforce. Earlier it was not there. Okay, that's one thing. So let me tell you, in international arena, America, USA is very reluctant to sign any international treaty. We don't have such reservations. We do sign treaties, and activist Supreme Court in Vishaka, and then which is that RBI versus where Section 6 of Gita Hariharan, all those cases, treaty obligations, though they don't bind us, courts have read them into our domestic law. I'll come to that one aspect. See, treaty is made by whom? By the executive. The treaty is made by the executive, but law is made by parliament. And the doctrine of separation of powers says what can be enforced is the law made by the parliament rather than the treaty made by the executive. Right? So, if India signs a treaty with another country, or for that matter, international treaty, with impunity, it can negate that and say that, sorry, I don't want to do anything with regard to that one. They can as well do that one. Of course, subject to our directive principle, Article 51, which says that you should foster peace and prosperity among nations, then you should not cause any breach of peace with regard to other nations, and then you should respect the treaties as well. That's persuasive, nothing beyond. In India, the difference is this. Treaty, as I said, is made by the executive. Law is made by parliament. So treaty doesn't become law directly. Whereas in US, Article 6, Section 2 of Constitution, US Constitution says, the moment a treaty is signed, it becomes part of the domestic law. So, it becomes part of their municipal law. So it has to be enforced. So they don't sign, because it becomes their law. Whereas you take Article 253 of Indian Constitution. It says, once there is a treaty, it should be made part of the domestic law, otherwise it can't be implemented. That's why the reluctance internationally you perceive on the part of the US, whereas India doesn't have such a constraint, because there are two ways. One is make it part of the domestic law by recognizing that one. It requires legislation, or else Supreme Court can read those principles into our jurisprudence. That's how it becomes presidential law. Without amending the law, it becomes presidential law. This is how that one comes. Then, when it comes to conflict of laws, how have we modeled ourselves after? Which is the guiding nation for us to have this private international law? Obviously, we copy the model of the English. The UK, we tend to follow their law. Mostly, whatever is applied there, we tend to follow that one. And there are other countries. See, when it comes to Commonwealth countries, not much of a difficulty. What's the difference? Would you mind my questioning something? So that we'll have good discussion. I think that I should have. why do we call Commonwealth countries?
We have been colonized.
You're right, thank you. Those who have been colonized by the British, though after their independence also, they still continued their affinity because of law, culture and all these aspects. They are called Commonwealth, except one country, which is that one? The US. It has refused to join Commonwealth. The rest of the Commonwealth countries. Well, these common law countries, not much of a difficulty when it comes to implementing because we follow the same set of laws. What happens if it is civil law country? Because conceptually everything changes. Civil law country. For example, common law always recognizes dual ownership. Take the example of tenant and landlord. If you have an agreement of tenancy, it requires to be registered. Why should be registered? Because tenancy is treated as property. Right? So, one property, two owners. The dichotomy of ownership is recognized under common law. For example, life estate holder. You could see under a will, under a gift, whatever, you can create a life estate. There will be a life estate holder. Then, that life estate holder will have absolute right vis-a-vis the property until his lifetime. If he wants to sell that, he can as well, technically speaking, sell that. But that selling or alienation will last only until his lifetime. Then it relapses and reverts to the reversioner or remainder person. So again there is dual ownership recognized. But in civil law, it doesn't recognize dual ownership. There can be only one owner. So there are certain problems when it comes to implementing internationally any judgment if there is a jurisdictional conflict or fundamentally conceptual conflict, civil law and common law. So most of the Commonwealth countries or common law countries have treaty obligation. Only a few of the civil law countries have treaty obligations with us. I'll come to that one. If a judgment comes from a civil law, a treaty country, and another one out of the treaty country, what could be the method we are following? Now, largely this private international law is guided by convention. For example, administrative law, is there any act for that one? Tort law, is there any act for that one? You just glean from various sources. So is the case with this private international law. But India has a bit of a codification in the form of two sections or a couple of sections for that matter. One is section 13 of CPC. The other is section 44A. Section 13 is an enabling provision. 44 is an enforcement provision. Then if you have other things that could be thought of, I can think of section 86 of Indian Evidence Act, which says that how a foreign judgment has to be recognized. And then you can think of section 45, how a foreign piece of legislation or judgment could be proved in a court of law. And section 74, which speaks about public document, can a foreign legislation or a foreign judgment be treated as a public document, dispensing with its proof, all these aspects. That's the academic stuff, I am avoiding that. Now let me come to the factual scenario. Now we have had these factors that section 13 says how a judgment should be recognized. Section 44A says how a judgment is to be enforced. Now, have you ever heard the expression called lex fori? Yes. What's the meaning of lex fori?
Is the law of the forum.
It's the law of the forum. Suppose the adjudication is taking place in India. All procedural law of that country should be applied, or of that court should be applied. That's called lex fori. What's lex loci? The law of the situs or the law of the country. Lex loci. That means, in a sense, the substantive law of the country which is to be applied It has nothing to do with forum. For example, the forum is in England, but the law to be applied is Indian law. So, procedural law is English law to be applied, and substantive law, Indian law to be applied. So, that's lex forum, fori, this is lex loci. And the third aspect is there, that is lex situs. Can anybody have an idea? Lex situs? I'll tell you. Lex situs means if something is corporeal, has a shape, then it has a place. So, for example, real estate, immovable property. So, the law of the place where it is located should be applied. Whereas, personal property, that is movable property, law of the place of the domicile, the person lives, that law should be applied. These are the nuances of that one. So, situs indicates how the property law has to be dealt. Now, when it comes to various nuances with regard to property, we call it real estate, right? What is the meaning of real estate? There is a good saying in English, what is obvious is apt to be missed.
So it's existent, you can see the real estate. That's all.
In a sense, you're right. And I would like to have historical aspect of this concept called real estate. Any idea? Law comes out of history, right? As Oliver Wendell Holmes said, it's not of logic, it's of one's life experience. And what's meant by experience? It's historical in the context, right? See what happens. Estate, if you have your smartphone and check any dictionary in that one, you can see the root estate, status, static, state, that means standing, right? The place where you can stand. You know what happened? Under English law, the entire property belonged to the king. The whole nation belonged to him. That's why we are paying taxes, right? So, it's king's property after all. He permits you to enjoy the property. Literally speaking, he permits you to stand on the property. So, you really can stand on certain property. That's how real estate has come. Every word has a story. Every legal concept has a story. If you remember the stories, you will never forget this. Right? I always tell my young friends that a soldier wants the finest weaponry. If he wants to fight, he may need sophisticated weaponry. For a lawyer, what is the sophisticated weaponry? Have you ever thought of it? I am like a dog's tail. I again come back to our lawyering. Right?
Vocabulary.
You are right, sir. You hit the nail on its head. Vocabulary. Right? Because when you articulate, right? When you articulate, even most difficult concepts can be explained. Even the most offensive things can be diffused. So that's why I always tell, go after the words. Fall in love with words. Every word is like an individual. The more you know about that individual, the more you remember about that man or that woman. If I say somebody is passing by, he is Mohan, I tend to forget next day. If I remember that he is Mohan from, say, Chennai, my improvement increases. Then I say that he is Mohan from Chennai, is a film artist, it still increases. It goes on. So are the words. So own up words. Have their history completely understood, right? And you take any word for that matter, you call maverick. What is the meaning of a maverick? An unconventional person, obvious meaning. Why should maverick word came about?
Sir, it came about from the, I think it's cattle, something who doesn't follow the rule.
Cattle?
Cattle.
I'll tell you, this Samuel Maverick was an American. He had a big ranch with thousands of heads of cattle. So those days, they would all look alike, they would be missing and they would be straying. They used to brand with the owner's name. This man refused to brand them, saying that it's cruelty, why should I do that one? Right? So, something unconventional you do, you become a maverick. Have you heard about the filibustering? Again, you can check your smartphones. Filibustering is, suppose in American Parliament, a law has to be passed. The session is coming to an end by 12 at night. So one congressman continued his tirade, his speech on the passing of the bill. Beyond 12 o'clock it lapsed. That's called filibustering, dragging proceedings until they become ineffectual. Okay, I have digressed. I know that one. I'm coming back. Now, let me come back. See, what I've said is, when it comes to the enforcement, the very purpose is uniformity in choice of law. When somebody comes to the court and he files a case and the pleadings are complete, then what is the next step the judge does? He strikes the issues, or rather he frames the issues. So in international law, this framing of issues is called characterization. Characterization is, I'll tell you, it's a very funny concept. There is one problem. There is a matrimonial dispute. Right? Husband says the marriage is a nullity. Wife says it's a valid marriage. Husband is from India. Wife is from the UK. So when matter comes before the court, it has to identify the issue based on which this nullity has to be sustained or to be discarded. For example, it is something like capacity to marry. Right? Capacity to marry. Or, in the alternative, the ceremonies, essential ceremonies as we talk about, Saptapadi, Agnihotra, etc. So, essential ceremonies. Then, please remember, if you are attacking the validity of a marriage on the question of capacity to marry, then the law of domicile will apply. This is striking the issue or characterization. So I have to identify which law I have to apply. For that purpose, you have to look at the problem that has come before the court. And the problem arises out of the disputed fact. And that dispute, if it concerns the capacity, it should be decided based on the domicile. That means, I am in India, my capacity to marry has come into question, and that has come into question in England. But still, the capacity is related to domestic law of India, because my domicile is this. Whereas ceremonies is not the domicile, but the forum or the place where the marriage took place. You take the example of Goa. Goa is the only country, only state that has uniform civil code, no political state. Then it's also a state which practices, at least in the area of property and succession, civil law. And if you marry, any of you not married, find a very rich boy or a rich girl, marry in Goa, 50% of her or his property will come to you. I have given you a clue. Do it then. That is law of the place. That's law of the place. If you marry there, that's called, what do you call? There's anybody from Bombay practicing, they can tell the particular technical word that is there. That is, what is that, unity of property or something? There is a word for that purpose. Or communion of property, something like that one. So it goes like that one. And prenuptial agreements, our people are very clever. Yes. So they wanted to avoid that one. Portuguese law, right? It's Portuguese law but adopted by India and completely it's been Indian law.
Some of the people using prenuptial laws.
What happens, prenuptial agreement is this. You can contract yourself out of that obligation by having a prenuptial agreement saying that, no, this property division should not happen. You can overcome that one, I was told, right? Alright. Now this is how these things happen. This is how the reciprocity comes into picture. Now, one last technical concept I'll have. That is Renvoi. Have you ever heard about Renvoi? I'll explain that with a simple example. You are my good friend. You have taken the trouble of all the way coming to my house. So courtesy demanded, your house is nearby though. So I come up to your house to see you off. Then you feel you have come all the way to my house. I should see you off, you will come to my house. And this circle goes on endlessly. This is Renvoi. And I'll put that in legal context and explain how Renvoi operates. Suppose an Indian is there and he's living in France. Right? French law says vis-a-vis his movable properties. I'm just giving a hypothetical example. French law says that somebody, an Indian, living in France, if he dies, with regard to succession vis-a-vis his movable properties, the Indian law should apply. And matter comes to India. Indian law says, when it comes to an Indian living abroad, dying over there, leaving movable properties behind, that law of location, lex loci, should apply. So I should go back to France. So French law says go to India. India law says go to US, sorry, France. So it goes on like that. This is called Renvoi. That's why parties agree to specify and to compartmentalize the application of law to avoid this situation called Renvoi. That's all the technicalities. Now let me come to the case law part. I'll tell you my favorite joke about case law. In Bombay I said, please don't follow case law because it kills originality. Because the moment you see some decision that's applying, you close your mind and you don't think, at least young lawyers, not the seniors I'm talking about, young lawyers. And how could you develop law? How could you have landmark judgments if everything has been covered? I've told you on the last occasion when it comes to how common law has come about and how equity has come about. When that, what do you call? Who is the one in 1100? That Norman king who came to England and conquered the whole thing and introduced common, William the Conqueror. So when he came, he felt that every county has its own different provincial law, it should be made common. So he appointed a group of judges. They were asked to sit in the Westminster, and from there they would go in circuit. That's why the practice of circuit came into existence, circuit judges. Circuit, and they applied same law commonly across. So that's how common law has come. So the judges stopped thinking in England. So every time somebody stands up and says, say in County Kent, that my problem is this, he will say in Middlesex I've decided this case, take this judgment, it applies to you. So it's become a routine thing, they are not applying their mind. Precedent has become an oppressive one. Then they started petitioning the king. Look, these judges are not deciding. Every time when I say that there is a problem, it's already been covered, take this one and go. So then the king said to his chancellor means minister, chancellor, that look into this problem, what should happen. So they got accumulated. He started sitting separately and deciding, saying that yes, that has been covered, but there is a certain distinguishing factor in this one, so it should be distinguished. Right? For example, somebody has been murdered and somebody has murdered the other person for the property's sake. There's a distinction. A murder is a murder. You can't say that. That's what the president has said. So these people have felt that it should be distinguished. So this distinction has given to Chancellor's court. So Chancellor, he was hearing all the cases, Chancellor. That's why it's called Chancery Division. That's why beyond the common law, law has been applied. It's become equitable law or equity law. That's how the distinction has come about when it comes to these things. Now let me come back to this one. So then, there I said that don't over-rely on precedent, it kills your creativity. And in Kerala, when I was there, one senior counsel argued a matter before me. See, when it comes to former judges, they always glorify themselves, at least to me. Right. There is an argument. He said, my lords, it's squarely covered by a Supreme Court judgment. He gives it. No, in Kerala, they don't cite Supreme Court, they cite Kerala High Court. So, squarely covered, full bench decision. Another judgment, another judgment, another judgment. 11 judgments he cited on the same point. He was going for the 12th one. I said, Mr. Senior Counsel, Certainly you have been briefed very thoroughly and your colleagues are very diligent. They have done the research and they have given the case law. But once you articulate a point of law and then you cite a judgment, it's like underlining. Right? By citing a judgment, you're underlining a point, otherwise, which may not be that much impressive. So once you underline, if you keep on underlining, the point will disappear. Right. Let me come to a very, very, very limited aspect of case law, I will say. And now let me take the first judgment. Now, essentially, I stop gossiping and I should fall back on my notes because otherwise I can't remember. Let me see. One is Moloji Narsingh Rao versus Shankar Saran. This is the first judgment I chose because it's one of the very fine judgments rendered in 1962. If you want, for record's sake, AIR 1962 SC 1737. You know what happened in this case? The issue was, what are the conditions that are to be fulfilled for a foreign judgment to have enforceability? Then they have listed out all things that are the parameters. Only these 4 things I read, the rest again my gossiping. First thing is that what's been said, the respondent, that's the defendant you can call, was not subjected to, suppose I am a foreigner, a case is elsewhere, in that case it's in Gwalior, I have not subjected myself to that country's jurisdiction. So it doesn't affect me. Jurisdiction is a matter of sovereignty, after all. Right, I'm a foreign national. I don't myself submit to this foreign national jurisdiction. The second thing is, I don't have any allegiance to that nation, not a citizen. And the third thing is, I have never resided there. And fourth thing, sometimes cause of action comes, but still that's not sufficient or enough alone. Then, even when at the time it's been instituted, I was not present there. Then, even when I have sued there as a plaintiff, still as a defendant I can as well refuse to have its jurisdiction. So they have listed out about 10 causes saying that these are the things court has to look at before enforceability can be considered. Now, that's one of the judgments that has, up to that 1962, reviewed the whole position and laid down these principles. You can read with profit. Now let me come to another one. You know what happened? Here, this is AR 1962 SC 232, Andhra Bank versus R. Srinivasan. You know what happened here? There is a guarantor. Right, there is a guarantor. And a suit was filed in a foreign country vis-a-vis a loan that guarantor, when he was in that country, contracted. Then he died pending the suit. His LRs were living away back in India. They were made parties. They never appeared, they never contested, a decree was passed. So it was sought to be enforced. Right. Then the question came whether these LRs are bound to be, because they never recognized that one, they never submitted to that jurisdiction. But they are the LRs. So what should be the position is the decision that's been rendered by the Supreme Court. They have said that, actually Madras High Court has said that they are bound in some other context. I'll come to that one. Sorry, they are not bound, but Supreme Court said that. That's the distinction, you can check. Then comes, other one is AR 1962 AP 400, Andhra Pradesh, AP means 400, it's a full bench decision. It differed with Bombay High Court full bench decision on an aspect. This is called Kukadap Krishnamurthy, then G. Venkatrao. You know, most of the names have been mutilated and almost murdered after their recognition thanks to typists in court proceedings. I told you, we always say for example, Maneka Gandhi versus Union of India. There, her name was actually Maneka Gandhi. The typist typed as Maneka, that stuck with her. Right? Right. We say Maneka Gandhi versus Union of India. What is this versus? Because I said about the typist context.
Ampersand reverse.
You got it, I am not repeating. Next question. Because there in Inns Court in England, all clerks were illiterates. So they could not write ampersand. And it is Maneka Gandhi and Union of India originally, not in Indian context, originally Marbury versus Madison. It should be Marbury and Madison. If you read Charles Dickens' Bleak House, there you will say John Dice and John Dice, not John Dice versus John Dice. Because Charles Dickens was a son of a law clerk. And to make his living, he was doing errands by supplying stamp papers, copies to lawyers, etc. That's why most of his books have legal themes. Please read, especially Bleak House. Right? All right. I'm coming back to this one. So here, when it comes to this one, a decree was passed against a person living abroad, otherwise it has got the cause of action and everything. But he refused to submit himself to that jurisdiction because there is no obligation. The court said, even cause of action has arisen, still he can refuse. That's the one judgment. Now let me come to another one. This is a very interesting case. This is AIR 1973 Madras 141. RMV Vellachi Achi versus RMA Ramanathan Chettiar. And you are laughing at the pronunciation. I know that.
It's Achi, sir.
Achi?
Achi.
Right. Achi means father or
No,
Ayya?
sir, no. In Karaikudi and other places, the female is called Achi, sir. That is the female head
Oh, it's a female title.
title, sir. Achi is a female title.
In Telugu we call Amma, Thai, something like that. In Tamil?
Yes, sir.
Right. Now let me see here. What happened? One company has been carrying on business in Singapore. And there is a dispute with regard to that one. The company was sued. And the partners were also made parties. The company obviously is subjected to jurisdiction, but the partner refused to be subjected to jurisdiction. Right. And Madras High Court then, in 1973, held maybe the partnership is liable, but not the partner. But don't you think it may not be right judgment with great respect? Because partnership is not a juristic entity. Once it's not a juristic entity, it's a summation or a compendious reference of the partners put together. If you read out of 30 rules 1 and 10, that's what they say. So in a sense, can we have a dichotomy? When it comes to companies, you will have the dichotomy. Unless you live the corporate wheel subjected to other conditions. But here, I don't think that's correct. But you know, precedents can always be questioned, can always be discussed. We should have intellectual freedom. And we should not go to that court and say that you are wrong, will be butchered. We should not do that one because it's a binding precedent after all. And we go to higher echelon of a court, then you can say that that's wrongly decided, etc., etc. But when it comes to a court, whatever has been decided, you can't overreach that with your judicial logic. A president is a president for all purposes, even if it's ex parte, right? Now, there's been said that he doesn't bind the partner. My reservations only for academic purpose, not otherwise. If I go there, I'll cite that to take advantage. Right. Now, another one is, again, AR 1933 Madras 112. You know what happened? It's a partnership and carried on, but they moved away, they came over to India, and then there they sued them. These people never appeared because it's an ex parte in terms of section 13, they said it doesn't bind. Now, here the court formulated these principles, Madras High Court, with regard to this submission of jurisdiction. Let me read that couple of sentences. Sir, in 5 minutes I'll finish. Where the person is a subject of the foreign country in which the judgment has been obtained against him on prior occasion, where is a resident in foreign country when the action is commenced, where a person selects a foreign court as a forum for taking action in the capacity of plaintiff, in which forum he is later, where the party on summons voluntarily appears, where by any agreement a person has contracted to submit himself, etc., etc. This is what court has said. Under these circumstances, it binds, right? Otherwise, it doesn't. Then I was just alluding. What's the difference? What is meant by difference between referring and alluding? I said we live in splitting hair when it comes to words. What is the difference between alluding and referring? If you refer, you directly talk about that. If you allude, you indirectly talk about it.
Alluding is hinted.
Beg you.
Alluding is hinted.
Guilt.
To hint.
Hint. You are right. Thank you. Indirect reference. Alluding is. There are funny things about that. We'll come to this one anyway. Because he's staring at me. He's staring at Raj. Right. Once I file a case as a plaintiff in a foreign country. Then I am sued as a defendant in another case. Am I stopped from taking a plea that it doesn't apply to me, I am not bound by the foreign judgment? The law is no. In different capacities, in different contracts. That's why there is no estoppel vis-a-vis that one. And another one, when a minor and a few other people were sued in a foreign country, and notice was sent, including the minor, that means the guardian of the minor. And this guardian, who has already been a party in his personal capacity, appeared as a person, but not as the representative of the guardian. Judgment has been passed, sought to be enforced here. Does it bind the minor? It doesn't. Because there is no representation vis-a-vis the minor, he is under an incapacity. So it doesn't. So, sir, there are a few, please. No, you can have questions, please.
One or two judgments, then it's fine, sir.
I believe questions will be more interesting.
Okay. Then we'll
So
go,
that,
first I'll go for vote of thanks, sir, then we'll go
So
for
be it, sir.
questions. Yeah. Thank you very much, sir. We enlightened so much this thing, several quotations, several words, judgments and other things. We are really, enlightened for every purpose.
Thank you.
True justice to the topic and all. We enjoyed every word. The literature, we have to learn a lot. Give a huge claps to the sir. Now I request Shivali Chaudhary.
I am humbled, sir.
I request Shivali Chaudhary give a vote of thanks. Yeah, I think let me take chair. Or you come this side. You come sit there. You take this one. Come.
I extend my gratitude to Mr. G.Seshagiri for inviting me to deliver the vote of thanks for this session of the Friday group. We sporadically swoosh by great orators in the corridors of the Supreme Court. Inside the courtrooms, we observe them fiercely defend the rights of citizens and ferociously defend our fundamental rights, but they remain elusive. It is on afternoons like this that we hope that our predilections will be satiated by a delicious rendezvous of academia with the finest legal minds. I am honored to be a part of this session delivered by Mr. Dama Seshadri Naidu, Senior Advocate and former Judge of the Bombay High Court, Kerala High Court and Andhra High Court.
A to Z.
We thank you, sir, for enriching our knowledge on enforcement of foreign judgments. To recapitulate, the Indian Codification, Section 13 CPC, Section 44A CPC, 86 of the Indian Evidence Act, Section 45 of the Indian Evidence Act, Section 74 of the Indian Evidence Act. Some notable cases are AIR 1962, SC 1737, this is for people who missed the citation, AIR 196, 2 SC 232, AIR 1962 AP 400, AIR 1933 Madras 112. And most notably, we thank you, sir, for spilling the beans. And this indeed is the takeaway. Secret number 1 for advocacy, sing, for it teaches you to mask emotion. Secret number 2, for mastering at least one journal religiously. And to conclude, fall in love with words, for vocabulary is the consort of advocacy.
Thank you, Shivali. So nice of you. Now we'll go for question answers. Any questions, please kindly.
Sir,
Yeah, please.
sir, in enforcement and like recognition and enforcement of foreign judgments or foreign award like arbitral award, how significant is the role of public policy?
Very significant for that matter. This is the one I missed. Thank you, you reminded me. Suppose two areas private international doesn't apply. One is penal laws. There's no private international law vis-a-vis penal laws. And the other one is taxation law. Unless the principle of territorial nexus and other things left aside, these two branches, it doesn't apply. And the third one is, see for example, a country may have recognized bigamy, may have recognized even polyandry. What's the polyandry? Yes, polyandry, whatever. And we have a reciprocal arrangement with that country. Can we enforce that one? No, because it's opposed to public policy. That's why that is the permeating factor of our whole judicial edifice or jurisprudential edifice, that public policy is the golden thread that runs through. Good question, and that's the area I've just missed out. Thank you.
Any question, please, quickly.
I have to catch my
Yeah. Thank you very much, friends. We'll take your